Hi, I'm Shakina Melbourne, a Detroit attorney with over 11 years of experience. And today I'm here to help you navigate one of the most important tools for landlords: how to properly fill out a demand letter, also known as a notice to quit. This is a critical step in addressing issues with your tenant, whether it's for non payment of rent, demand for recovery of possession. Either way, a demand letter starts an eviction case. And it's very important to start this form correctly because when a landlord has a problem with a tenant and needs it to be addressed, the court wants to make sure: did the landlord offer a demand, giving the tenant an opportunity to cure any defaults, such as a non payment, or cure a violation in the lease before coming to the court and looking for help? Now, the one thing that's important, especially in the year of 2025, with all of the changes that have taken place during the pandemic, is the landlord following the terms and conditions of the demand letter? Because honestly, if not, that's one of the first things the court looks at, or the attorney that's representing the tenant looks at, is: was the demand letter filled out correctly? Were all the boxes checked correctly? Were all the signatures there correctly? And honestly, failing to do that the right way is automatically a case that, once the eviction case is started, will cause the case to be dismissed. And you're like, well, how is that possible? I did everything right. Well, did you? Because that's usually what ends up going wrong. And so our goal today is to go over the demand letter. And as a landlord attorney myself, I get a lot of demand letters, believe it or not, that's filled out by the landlord that's honestly incorrect. And no landlord wants to hear that they've already waited the necessary time frame for the demand letter to expire to then find out they have to start all over. So, in our video today, we're going to start with a demand for possession called for a case that is a non-payment of rent case. And non-payment of rent, you already know, but it means the tenant failed to pay. And the expiration period on a demand letter is 7 days. After the 7 days have expired, the landlord must wait 10 days before they can go to the court and file the full eviction case. But let's make sure we know and understand how to properly fill out a demand letter. So, step one starts with making sure the tenant's name is correct. Many courts see this differently, but my recommendation is always to put the tenant's name and all occupants. Why all occupants? If you cover all occupants, that means if the tenant ever went and had someone else move into the property, or if the tenant had someone else living with them, you want to make sure the tenant and everyone living in the house, condo, single family, duplex, this even applies for commercial spaces too. You want to make sure every person that has any interest or any personal property within the space is notified that an eviction case is taking place, right? After that, we make sure we put their address: 1123 South Street. We're going to say Detroit, Michigan, 48214. Okay. Always put the entire address inside of that box. The court looks at, when an eviction case is filed, the eviction case is the summons and the complaint. When they look at the summons and complaint, they will look at, do the addresses match what was originally put in the demand letter and what's listed on the documents that's filed with the court. If they do not match, the court can say, I'm not sure, and we're going to dismiss the case because we don't know if the tenant truly got notice in advance of this eviction case, even if the tenant is at the courthouse that day. Can you imagine that? They're going to say, nah, you didn't give them enough notice, so start all over. So it's important to make sure their names, occupants are listed, and the correct address. Now let's talk about your landlord landlady section. This has come up so many times in 2024 that this has caused many cases to either be dismissed, cause cases to have adjournments. Adjournments means future court dates, and extend out an eviction case after the case is filed because the incorrect person is listed as the landlord or landlady on the demand letter. So let's talk about who should be the landlord or landlady. The landlord or landlady should only be a property manager or and the owner or the name that's listed on the deed to the property. Wait, what? Okay. A property manager alone cannot evict a tenant like they did in the past. Because so much fraud took place during the pandemic, the courts now want to know who actually owns the property and that the owner is not only just listed on the demand letter, but they are also listed as the plaintiff in the eviction case. So when we're filling out the landlady section, make sure you're looking at the deed to the property, whether that is your personal name, an LLC that's now the owner of the property, if it's the property manager, you want to put property manager / owner, property owner. And like I said, a property owner could be anyone from the deeded individual who owns it or the company. My screen don't go that far. The paperwork don't allow me to go that far. But you understand what I'm saying. The individual on the deed, the LLC, or the corporation, or the nonprofit, whatever business structure that may be deemed the owner of the property, and the property manager, but not just the property manager alone. Next, we're going to look at subsection C. As you see, the demand letter has these little small sections in there to give you an opportunity to know one step at a time what you should be doing to properly fill out this form. We're looking at how much rent is due. So if you have a rent ledger or you have a form you're filling out that you figure out how much the tenant actually owes, then you want to put that amount in here. So let's say they owe $3,000, which includes rent, late fees, your past due utility fees, anything that you and your tenant have agreed to on what you calculate every month and expect to bring in every month, and what they have not paid is what you're going to put in subsection C. A common area I see that most landlords or property owners, property manager companies fail to fill out is subsection D. Believe it or not, this again is a section that can cause your case to be dismissed because you didn't tell the tenant which address you were attempting to evict them from. Are you serious? So I done put subsection 2, put in the address in the first section, and the court is going to say, well, you didn't give them notice on which property that you were evicting them from. I know, it sucks. But again, whether you are doing this on your own as a property owner, manager, or you're working with an attorney to help you with your eviction cases, these are reasons why a case can get dismissed and you have to start all over. Please fill this form out correctly. All that we went through was just the top and subsection number 1. Now we're going to subsection number 2. One of the things I do want to make sure I'm emphasizing in this video is that this form is based on the state of Michigan alone. Every state may have their own style court forms or process and procedures for a landlord tenant case, but in the state of Michigan, this is how this works, okay? Now, number 2. Number 2 says, and I'm reading verbatim, if you owe this rent, you must do one of the following within 7 days. Please check that box. It is not assumed it's 7 days because you are filling out a demand letter that says non-payment of rent. It is not assumed that because you already know it's only 7 days and the court know it's 7 days, that it should only be 7 days. I want you to know we have some court-appointed attorneys that represent tenants, and their jobs are to figure out how to get your case dismissed. You didn't give them how many days they have to pay the rent. your case should get dismissed. I know. Now, you're going to check the box, and it gives them the options. Look, it says pay the rent owed or move out. Shocking. Okay. Please note, though, that these are the terms that exist when you get to court. If you file a demand for non-payment of rent and you file a eviction case to the courthouse for a non-payment of rent case, please understand that the tenant has one or two options: pay and stay, based on subsection 2 here, pay and stay, pay the rent, or move. Meaning, if they fail to pay the rent, then they move. But if they pay the rent, they get to stay. You don't get to go to court 3 months from now and say, oh no, I just want them to move out. No, the court is going to give them an opportunity to pay. And if that means they have the option to pay through a government assistance program, if that means they're going to pay because family and friends is going to help them, the court is going to give them time to see if they can pay the rent before giving them a move out date. Under subsection 3 and 4 is just for entertainment purposes and education purposes only. Now, section 4. I had an entire case dismissed over the fact that section 4 was not filled out correctly in a demand letter. What? It's only your date, signature, address, and phone number. And they'll still dismiss your case because you didn't put a date here, so we don't know what day the 7 days started. Huh? We don't. It specifically says sign. You don't get to put your business name right here, Upton Law PLLC. That's not a signature. If you don't sign it, we don't know whose signature this is. We don't know if this is the owner's signature. We don't know if this is the agent of the landlord or somebody playing games and who are just trying to get into the space. Case dismissed. This literally happened last month, and we had to start all over. Make sure your address is there, and it can't be the address for the property. So if you have a business, pick a business address. You should have a business address. You want to make sure you have a city and zip code. Now, if you own properties in the state of Michigan, but you live outside of the state of Michigan, that is perfectly fine too, to put your address outside of the state of Michigan in this box here. But what matters more is that the court knows which address it came from that sent the notice to the address that the tenants were in, so that they have notification of their move out or their option to pay. And make sure you put a phone number so that the tenants, you're going to say, well, they're the tenants. They know how to get in touch with me. Sir or madam, you need to put a phone number, because if we go to court and ain't no number, the judge going to say, so how did you expect them to pay, or let you know that they wanted to pay and stay if you didn't give them a phone number on the form to call? What? Yes, but it's real. Okay. The day that you are filling this form out, please make sure that same date is under letter G. If it is not, what the court's going to say, well, what day did you give any of these options to deliver the information that this tenant needs to pay or stay below? We're going to put tenant's name and all occupants here, because that's who we're serving this notice to quit to. Now, you must say, how did you submit this notice to them? Did you personally serve it? Did you give it to a family or friend over the age of 18? Did you send it by first-class mail? Did you offer it by electronic service, which is email? And please note, the only way you can use the box of email and the email address is if your lease agreement says you can give notice to your tenants by email. If your lease agreement does not include language that you can give notice by email, you cannot give notice by email. Period, point blank. They know in betweens, ain't no let's bypass this. We normally communicate by email and text message. It's not an option, okay? The judge don't know you. the judge don't know your normal practice and procedures with this tenant, and they're going to want a copy of this lease agreement, and they're going to look that it does not say email is allowed as notification, and then your case is dismissed. And you're going to start all over by mailing a copy of your notice to quit. So I suggest always mail. You can mail and send an email, but do not solely send an email unless your lease agreement specifically has language that says you can do so. Please make sure you're signing under Section F and you're signing down here. Your demand letter typically comes in 2 pages. Your first page is the copy that you're going to submit to the court when you're filing your eviction case. That includes your summons and complaint. You'll know because the court is who wants to know, how did you serve the occupants? But on page 2 of your demand letter, you're going to see at the bottom, it says how to get help. The second page is the copy you're going to send to the tenant, occupants of the space, because at the bottom, you'll see it gives them options. Call an attorney if they need help. Call the State Bar of Michigan to get some referral services if, again, they need help. If you don't have an attorney and you need help from legal aid or legal services like the Michigan legalhelp.org, then you can do so. You'll also see, again, this is how much this form is so important. Tenant's copy is at the bottom. Tenant's copy. So tenant copy, go to tenant. Court copy on the first page goes to the court. You keep the first page, print the second page, mail it, deliver it to the tenant occupant. I hope this helps. If you have to go back through this again, if you have questions, comments, and concerns, let me know. Let me help you, because honestly, more cases are getting dismissed off of technicalities right now, simply because no one knows how to fill out the form. And honestly, there's not many videos that tell you how to fill out the form. So you're lost anyway. And you don't find out until almost 2 months later after your case has started, where they say something's wrong and you got to start all over. Now, please note, filling out a demand letter doesn't have to be complicated, but it's definitely a crucial part of protecting your rights as a landlord, a property owner, or even a property manager helping a property owner. So like I said before, if you have questions, further guidance, just say, I'm not interested and I just need an attorney to help me do the whole thing, count me in, okay? Because I'm willing to do that for you. You can reach out to me through Minnect, Minnect, which would allow me to do text messages back and forth and real quick to help you send an email. You can set up a consultation. You can go to askshakina.com. You can go to the law firm, Upton Law, PLLC. You can call us. We are here. We are here to help you, offer you business resources, offer you landlord help assistance. Call me. I got you.